of civil law already. But in civil law, we have a victim who brings a case against a person who was harmed. So in evicted, we have landlords bringing lawsuits against tenants, the landlord being harmed by the tenant not paying their rent, versus in criminal lawsuits where the prosecution is being brought on behalf of society. So because of a harm to society in the safety of society as a whole. So prosecutors are, arguing for the people, right? You remember that from the presidential campaign slogan that Kamala Harris used. A tort is a wrong for which the law will provide a remedy. And so tortious claims are claims where someone says, I was hurt by you, and so you owe me money to compensate me. There are different kinds of torts, and we're going to see some of those in action in the films this week. Um, there's an intentional tort, a negligent tort, and a tort for which someone has strict liability. You don't have to know exactly what I'm talking about here, except to know that basically what we're doing when we're talking about a tort claim is figuring out if the person who is claiming the injury can show that the person who they are saying caused the injury did so in an intentional way or a negligent way. And when we're talking about negligence and the standard that has to be met to say that someone was negligent, we have to be able to use a reasonable person standard, which basically says that the person who injured the other person, their behavior violated what a reasonable person might expect from them, and so was the cause of the injury. And so when we're looking at tort cases, we're generally looking at harm done to an individual and then attempting to ascertain whether that harm was caused by the particular person that is being sued in court. And then that person then is going to be made whole by the person that they've claimed has injured them, either probably through some sort of monetary payment, which can come in compensatory or punitive damages. Compensatory damages are damages that just compensate for the injury. So medical bills, if you miss some time at work, you might be paid for your time at work. Crashed your car, you might be paid for the replacement of the vehicle. And then punitive damages are damages that are seeking to punish the person, attempting to try to stop them from behaving in this negligent way in the future. And all of these things are determined in court, right? And so some of you are doing a policy debate where you're trying to understand whether we ought to provide attorneys for these kinds of cases, right? So we looked at in the policy debate immigration cases. We looked at cases involving landlord and tenant disputes. Here, we're going to see the deployment of attorney representation in civil litigation. They often work on the basis where they're only paid if they win. Um, So we'll see how that works in terms of the quality of representation here, because again, we're not requiring representation in civil cases, and so that's obviously going to affect whether or not people bring cases, whether they're able to get an attorney that's willing to take the case. Um, and so that's going to be that can be definitely be part of that policy debate, certainly part of something that we'll talk about. And so one of the things that I think a lot of people sort of hold to in terms of their feeling about the way that the United States civil litigation system works is that we are an overly litigious society. And so there's sort of this general understanding that we sue over everything, right? And there's some, cause for that. We do have lots of stories of ridiculous lawsuits. And so I'm going to talk a little bit about an article. It's an essay by Deborah Rhodey from 2004, and it was in the Duke Law Journal. And she talks a little bit about this idea of frivolous litigation and whether or not we are overly litigious as a group, as a country, as a citizenry. And she says that, if we look around at other countries, if we look around at our own behavior, and try to attempt to ascertain whether or not there is evidence for this claim that we're overly litigious, she argues that we're not. So while she tells stories about really, she calls it loony litigation, she says there's, no problem finding stories. And so she talks about lots of silly stories about things like football fans who sued referees, prison inmates who sued for chunky rather than smooth peanut butter, mothers who asked a court to resolve a playground shoving match between their 3-year-old children, a purchaser of Cracker Jacks who demanded damages for a missing prize. And then some others, something about a cat in a microwave. I don't want to talk about it. So lots of litigation can be pointed to as being frivolous. So there are stories, right? And one of those stories oftentimes is about a woman who sued McDonald's over a hot coffee, right? One of the stories we tell in this sort of lore of our over litigation. But these stories tend to be overestimates about generalizability, and they tend to not be overdrawn randomly. Instead, they're a very systematic attempt to overdraw those cases and to make them feel much larger. In terms of actual statistics, it appears to be the case that litigation in the United States is declining. If it is increasing, the only increase in litigation is among divorces and business disputes. Punitive awards, so those awards I told you about that punish the person or the company who is at fault for some sort of tort violation, are very rare. There is no evidence that states that have higher limits on punitive awards in medical malpractice suits have any connection to increased healthcare costs. And it is the case that interest groups are extremely interested in limiting tort claims. And so the United States Chamber of Commerce and the American Tort Reform Association are very active in attempting to get regulations placed on the extent to which people can bring tort claims, products liability lawsuits, those sorts of things. And so what Professor Rhodey does is she looks through a lot of cases and a lot of different behaviors and finds really that if there's anything that she can find in terms of an effect of litigation, it's that it improves the safety of our products. So she does not find an economic effect that is negative. Instead, she finds a positive effect of safety. She says the larger problem that we have, and it is real, is that we don't compensate the victims to the degree that they need to be compensated. This is something you're going to see in the Hot Coffee documentary. And we overcompensate lawyers. So lawyers end up getting a lot of money, even when they take cases without, upfront compensation. And so what she says is that what happens is lawyers aim at higher compensatory and punitive damages for lawsuits. They reject settlements that they could have gotten, or they get higher settlements in order to get a bigger payoff for their representation. And so more of that money goes to the lawyers than to the victims of the malfeasance or the bad decision making or the unsafe product. And so we end up with tort reform that limits compensation of victims, but no regulation of how much money lawyers make when they take their cut of the settlements. And so that's what she sees as the larger problem with this set of cases. And she also sees that there is just too much unpredictability in this system. So it's an inefficient system because we don't have anything, like we have for like vaccines where there's just a compensation fund. It's inconsistent in that juries award different awards for different cases that might be very similar, but they just sort of felt differently about the case. And it's inequitable. So different cases are treated differently. And so she thinks that the core of what litigation in the United States over tort violations ought to be is a way to resolve disputes, a way to make sure victims are fully compensated for their injuries, and a way to deter future violations. And so that's what we should focus on. And if we're not getting to those things, and remember, she mentioned that we're not compensating victims to the level we ought to, that's what we should reform. Instead, what we see reformers focus on is discouraging litigation primarily, and we talked about why, which is this interest in these interest groups, managing legal claims better, and reducing the need for litigation. And that's what we really see reforms focus on. So she argues that the best way to fix the problem is to go to a no-fault system like the vaccines, to use specialized tribunals, to use alternative dispute resolution with checks and balances, and to try to reduce the need for litigation. So she agrees with that last piece that reformers have focused on over time. And so this article, as well as a whole bunch of other literature on point, really works to try to abuse us of this notion that we are overly litigious. And so I want to offer that to you as an informational point for the next time you hear people complain that we sue over everything, because we really don't. I'm going to tell you more about that reason in a second. So hot coffee is one of those cases that people point to when they want to talk about how overly litigious we are and that we sue over everything. In that particular case, if you remember it at all, which you may not remember it because it's from a while ago, but if you remember it, or if you heard about it, or if you ever looked at your cup and thought, why on earth does this say coffee, caution contents hot, right? It's all because of this case. In this case, we find an alternative reality, and it's fascinating. So, we end up seeing the public being led to believe things about the case that are not true, by a media that is motivated by a bunch of different things. And, maybe none of them is the truth. And tort reform movement that uses the case as a poster child for reform. And there's this great law review article that I have sometimes assigned in class, but it's exceedingly long, that I want to tell you a little bit about that kind of tracks this movement of this case. So in this case, we end up with a public that is led to believe she was driving. She was not. That the car was moving. It was not. That her injuries were minor. They were decidedly not. And that she attempted to sue McDonald's to get rich. She did not. It was accompanied by a PR campaign about the case, despite the fact that there were many previous complaints that McDonald's was knowingly brewing their coffee at temperatures they knew to be unsafe, that the jury in her case was unanimous, that the punitive damages were reduced by the judge, but were actually based on something very rational. And the media made the case into a joke. The tort reformers, as I said, used it as a poster child for what was wrong with the civil justice system. They hired PR firms that used names that sounded like citizen groups. Journalists largely fell for it. Part of that was because the attorneys in the case didn't do a good job of telling the story, and part of it was because of the motivations and incentives of the media. And a lot of this relates to what we learn from the Rhodey article about sort of the general expectation that we just over litigate. Um, and so the law review article is called Java Jive, the genealogy of a juridical icon. Michael McCann is a political scientist, and he writes with, I think, a couple of law professors. Um, actually, I think they're all, well, no, yes, another political scientist, Haltom, and then Ann Bloom, who's a law professor. And they spend this article as well as an entire book talking about the amazing way in which the McDonald's coffee case was consumed by the American public. So what do they say? They look at a couple of different what they call narratives. So they say that when the media reported on the case, they could have chosen one of two narratives. They could have chosen a defective products liability narrative, or they could have chosen an individual responsibility narrative. And as you might imagine, they chose the individual responsibility narrative, which is very consistent with many of the other things we've talked about in our class, right? When we talked about poverty, when we talked about um, recidivism. Using this defective products liability narrative, um, the media could have talked about the dangers of the temperature at which McDonald's was brewing coffee. They could have talked about the knowledge that McDonald's had about the dangers of that temperature. They could have talked about the many complaints that McDonald's had received from consumers about how hot the coffee was. Instead, they talked about individual responsibility. So they talked about the fact that um, the person suing McDonald's was older. They talked about that she didn't remove her clothes immediately to make the burn less problematic. They talked about the industry standard of people wanting hot coffee when they buy their coffee. Um, and they used her as an example of a plaintiff attempting to get damages for something that she did herself. And so the general story about how torts are this terrible thing that we do to ourselves in this country, and where we're trying to, we tripped and fell, and so someone else should pay, or that we somehow manufacture these crises and then obtain money through a lawsuit, through a frivolous lawsuit. And the jury agreed with the plaintiff. The jury agreed unanimously with the defective products liability narrative, but the media decided to put out the other one. So the interest groups, the interests of the media, and the sort of expectations of the public combined to change a story about a badly burned grandmother into this icon of runaway litigiousness. So if you've heard of the hot coffee case, you have probably assumed that she is, just trying to make some money. So why is this important enough to talk about? It's important enough to talk about because we should have learned long ago that stories shape policies and practices, right? That when we have stories to tell, the way we tell the stories, the way the media shapes the truth, the way we understand what we're hearing and seeing is going to affect the way we behave. And it's going to affect the policies that we pass. It's going to affect the practices that we adopt. So, media cares about newsworthiness, right? They care about personalization. They care about dramatization. They care about fragmentation. They care about normalization, We're going to see all of those things in the coverage of the McDonald's hot coffee case. Um, I think, do I have a media studies person in here? I think I do. So, we'll want to hear from them if I do. I think I have a couple of you. But the coverage, is in phases, so there's not a lot of attention to the case before the jury's decision. So we don't hear a lot of the evidence. We don't hear a lot of the prior claims. We don't hear a lot about what McDonald's is doing or what they know. We then see the jury's decision. So we drop the drama, right? So every newspaper leads with the money figures and they underplay her injuries. We personalize it. We don't talk about McDonald's, we talk about her. We talk about the individual that she spilled her coffee, right? We present the case fragmented. We don't do a holistic account of everything that happened. We don't give any science. We don't talk about the pain levels she's in. We don't talk about her suffering. We don't talk about her earlier complaints. We don't even talk about the fact that all she wanted from McDonald's was enough money to cover her medical bills. We just talk about this big dollar figure in this drama. And then we also normalize it. So we just call it another crazy lawsuit, another example of our, jump to litigiousness. So whenever there were gaps in the coverage from the media, that provided an opportunity for editorialists to fill, and the interest groups were happy to oblige. So we hear a lot about litigiousness. We see a lot of hyperbole. We get the defendant characterized as reckless. We see faulty inference and invention. So this idea that I talked about at the beginning, the location of the incident. We start talking that she was driving, or that she was in the drive-through, or that she was in the driver's seat, right? None of those things were true, but that's what we start hearing about. Dollars hollering is something that they talk about in media coverage of lawsuits. So we hear a lot about the jury's amount of money. And then the TV's coverage is even worse, because TV coverage is always worse because it's so much faster and it's so much more image-based. So the implications of this case study, of this particular instance of litigation, is that the ways in which the news is reported and the media sees the news, along with our preconceived notions of civil litigation, ends up constructing events in problematic ways. We end up supplanting a real person who was badly burned. And you're going to see that in the film with a caricature. We create a new reality and a new construction of what's legal. This provided fodder for tort reformers whose timing was perfect because they had the perfect legislature and president. Trial lawyers didn't give enough information to the media. The corporation and their attorneys didn't give enough information to the media. Liebig, who is the victim here, ends up being victimized twice. So not only does she get harmed by McDonald's and then not compensated, but then she gets harmed in the media because of the way she's treated through the reporting of her case. And this also affects how we view courts, right? I'm doing a course in the fall on called Law Through Popular Culture. And one of the things we do is we watch films and television shows to try to understand how their portrayals of lawyers and judges and courts and juries affects the way people see the courts. We could just as easily cover media attention to the courts because this kind of coverage also affects how we view courts, right? So if we see these kinds of stories, we start thinking about, this is what trial lawyers do. This is how they act. This is what courts do. This is how they harm society. This is why medical healthcare is so expensive. This is why, babies are so expensive to have. All of these lawsuits, right? This is such a drain on society. We have all these notions because of the way these things are presented. And so this matters because that matters whether we bring cases to the court, and it matters how we feel about the court and whether we'll participate in the court as jurors or as witnesses. You'll see other stories in the documentary as well. So not just the hot coffee case. I don't have literature or any other long law reviews to talk about on these other cases, but you're going to hear about caps on damages, which is referred to in the Rhodey article. And that is affecting the case of the Grueling twins. So take a look at that. Think about how that relates to what we heard on the Rhodey article about tort reformers. You're going to hear about judicial elections. Here we've got a judicial candidate who gets targeted by the Chamber of Commerce. You're going to hear a little bit about the United States Chamber of Commerce. I think a lot of people think this is a governmental agency. It is not. It is an interest group for businesses. So you're going to hear a little bit about what they're engaged in terms of their activity and their spending. And overall, you're going to hear sort of an argument from the film and from scholars about the civil justice system and what it does well and how it's mischaracterized. So I think they both make the point that civil litigation can hold people accountable or hold corporations accountable for their bad actions. It can afford access to government for one person to take on a big, huge institution or corporation in a way that no other branch of government would allow. It allows people to get justice for a big group of people. It points out this disagreement about frivolousness and whether or not litigation tends to be frivolous. There are media campaigns that it draws on. The films will talk about these as well, telling you about the Chamber of Commerce's activity and the American Tort Reform Association. It suggests that we are not so litigious as you might think we are. And that there are not so many wins and not such huge punitive awards. I want you to pay attention to what the McDonald's Award is, by the way, and how it's related to McDonald's. The real problem, as Rhodey suggests, is undercompensation of victims and overcompensation of lawyers. There is a result of deterrence as a function of these lawsuits. But the way that these lawsuits act or the way that these lawsuits go through the system ends up being problematic and problematic enough that we might want to consider other ways to settle them and think about why we might turn to courts in the first place. So I think the Erin Brockovich case gives us some idea about whether or not people turn to courts too soon or too easily. And I have some research on that too. This is a Law and Society Review article, which some of you have read one of those for your policy debate. And this is William Felstiner, Richard Abel, and Austin Surratt. Austin Surratt's a very famous political scientist. And this paper is an attempt to understand the degree to which people run to court whenever they have a problem. And so this is called the emergence and transformation of disputes. And their main sort of handle is that people don't rush to courts. In fact, it's very hard for people to transform a dispute with whomever they're disputing something into a legal claim. And that in order to do so, they have to name, blame, and claim. And so they look at each of these steps in the process of transforming a legal dispute. And they say that at each of those steps, it's difficult for people. And you're going to see that play out, I think, really clearly in Erin Brockovich. So they argue that it may not be the case that there's too much litigation. Indeed, it may instead be the case that there isn't enough. And so they look at a bottom-up perspective. So instead of looking at what courts are doing and how people are reacting, they're looking at what people are doing and arguing that this kind of research agenda gives us some insight into people's behavior and how that trickles up to the court, which is an important thing to understand. And their key arguments are that disputes are social constructs, that, like a lawsuit doesn't just happen, right? You have to decide to make something into a lawsuit, and that there are three stages in the development of a dispute. So, first, you have to perceive yourself to have been injured. And that isn't as easy as it seems. And you're going to see that in Erin Brockovich. Second, even if you perceive yourself to have been injured, you have to be able to attribute your injury to someone else. You have to be able to blame them. And then, even if you can name your injury and blame someone for it, you have to be ready to ask for a remedy to that injury. So you have to make a claim. So we need to know which claims go unmade in order to understand the propensity of people to make a claim, right? So if we want to know, how frequently or to what degree do people make a legal claim out of everything, right? So our argument from before is that, people will sue over everything. If we really want to know the answer to that question, we need to know how many times people just lump it, right? So how many times do people go, well, my kid broke her arm at the neighbor's, but, we're friends. We don't want to make a federal case of it, right? You've probably heard that song, that saying, right? Not going to make a federal case of it. Kind of the point of the article, right? When do we bring these things to court? When do we make a claim? Understanding this process and understanding how many disputes there are in the world versus how many are actually brought to court kind of give us an idea of how often people actually use the court system. So they talk about how difficult this is, right? So that, transforming an injury to a claim is subjective. Only the injured person knows whether it's claim worthy. It's unstable. People might think something is a claim early on and then decide it's not later, or opposite, or vice versa. It's reactive because it might matter if somebody freaks out about something that happened to you, and that might make you think differently about it. It's complicated because your feelings are involved, right? My neighbor, I like my neighbor. I don't want to sue my neighbor. Um, it's hard to remember some things, right? And then it's incomplete. Like the dispute never really ends. So you never really know when you've decided not to do it. And so to study transformations in this particular paper, they look at whether or not people contact an attorney, and they look at various variables that they think might matter to that contact. They look at who's viewed as being at fault, the scope of the conflict, the choice of venue, the objectives that they seek, the individual's ideology, other people in the claimant's life, the officials involved, institutions designed to resolve the dispute, and then and they're looking they're not asking people about these things, they're actually looking at those interactions over time. And so their argument is that it's actually really hard to and this is just a research design actually. They don't actually do it. They're just sort of advocating for this approach. And their argument is that, it's hard to actually engage in this process. That you might be, if you take a beat, able to think of several instances where you could have sued someone for something and you chose not to. So take a second to think about that. Have you ever considered legal action? When? What did you do? And why? So have you been harmed by a corporation? Did you get hurt at an event? Has your family ever been involved in some sort of a disagreement over a contract? Has a neighbor planted a tree on a property line? There's lots of reasons why you might have been engaged in some sort of a conflict that could have been transformed into a claim. But we, for various reasons, decide to lump a lot of these things, right? So we could have sued the neighbor when our kid broke their arm on the bouncy house or whatever it is, right? But we might choose not to because we want to maintain that relationship. We could sue McDonald's when we got coffee that burned us, but maybe our injury wasn't so bad and we didn't want to go through the whole process, right? You have to get a lawyer, you have to file papers, you have to do all these other things. It's hard. It takes time. It involves relationships. There's lots of reasons not to do it. And so what their main point in their article is that for so long we have said that we are overly litigious. But what they're arguing is that we need to recognize that it is sometimes very difficult for people to translate an injury into a claim that has blame. Um, First it has to be named. I feel like Happy Gilmore right now. Did you guys watch Happy Gilmore too? It was very stupid, but anyway, so something to be named and then claimed and then blamed isn't so simple. So you're going to see this in Erin Brockovich. You're going to look at how difficult it is for a law firm, especially a small one, to bring a tort case against a huge corporation. You're going to see how difficult it is for the people in the town to perceive that they have been harmed, first of all. So even just naming that they were harmed, and then to translate that harm into a claim, and then to actually assert that the company or the corporation was to blame for their harm. Really difficult for Erin to talk people into feeling or deciding that they've been harmed. And then the reality is shown in this film as well, that most cases like this don't go to trial. Most cases like this are settled. There's also the vexing issue of compensatory damages. How do you decide what certain kinds of health damages are worth, right? Like, how do you put a monetary value on certain things, like the ability to have kids or, you know, um, a lung or something, right? And then also their perceptions of courts and attorneys, I think, are really, really show up nicely in this film. So watch for the cameo by the real Erin Brockovich, and really think about this idea of translating some sort of harm that's done to you into a claim, naming that harm and claiming it as a legal wrong, and then placing the blame on someone. Watch how hard it is for the people of Hinckley to do that, and then think about that as it relates to this question of litigiousness. I just want to give you a few additional notes on some of the potential consequences of civil litigation. You're going to see them in Hot Coffee. You're going to see them in Erin Brockovich. I just want to give you just sort of a broad-based view of some other areas where we see the impact of civil litigation and some areas where we have resisted that. So litigation, according to Vernick et al., and this is an article in a medical journal, um, the American Journal of Public Health. Argue that litigation can be an important way to reduce injuries from products through motivation. So this is, we've talked a lot about incentives in this class to make safe products. So what they argue here is that, sometimes corporations don't have an incentive to make safe products. And so litigation can provide that incentive. So you can do that in three ways through litigation, and you're going to see some of these things in the movies as well. You can do it through money. So we talked about compensatory and punitive damages. So money can be paid to victims that can make the company less likely to behave in the ways that made them end up paying out, in the future, right? So it protects future consumers from the dangerous products. It also provides motivation through discovery. So in a lawsuit, when you are engaging in civil litigation, part of the main benefit of going through the courts is that there will be a process of discovery where you're doing an investigation of whether or not the behavior that is being alleged actually happened. That investigation involves discovery where the claimant gets to see what the respondent has in terms of information. You're going to see that process in Erin Brockovich. They have to produce documents. When they get those documents, a lot of information about products will come to light. That's motivation to make safe products. And then the publicity that happens as a result of those litigation, those cases, will create public demand for safe products. So all of those make the law, or can make the law, a powerful tool for safety. And so we've seen this in lots of different areas of product safety in the United States. And we have also seen that when we ask manufacturers, they point to litigation as promoting some of that safety. So we know that a survey of manufacturers said that labeling, quality control, product design was driven by a desire to reduce liability. That a study by the RAND Corporation suggested that liability was a big factor in design decisions, even more so than government regulation. The conference board said that instructions or warnings were improved because of liability concerns, and that punitive damages improved safety as a result of their having to pay those punitive damages. There are downsides to legal redress in this way, potential costs of liability litigation. It can stifle innovation, right? So companies can be afraid to innovate because they might be afraid of being sued. It can provide disincentives to apply new technology to old problems, and it can add costs, which can hurt competitiveness. So all of these things can make companies more conservative, right? Because they're trying to avoid liability and avoid those claims. But generally speaking, we find that empirically, outcomes are positive. In terms of examples of